Thank you, Michelle. Good day to all of you. And on behalf of the KwaZulu-Natal Society of Mediators, I welcome you all to the first in our quarterly series of lunch hour webinars. I am Ishara Bodasing, a practicing mediator, trained and accredited with conflict dynamics, and I am also chair of the KZN Society of Mediators. Let me start with a short introduction on who we are as a society. We have formed a voluntary association with membership of the society being open to all mediators who operate in KZN and who subscribe to certain accreditation standards. The society's objectives are to create a centralized platform for and of mediators in KZN, to advance and promote mediation, to promote ethical standards and integrity in the practice of mediation in KZN, to also represent and act as a voice for our members in engagements with third parties. Our objectives are also to promote the exchange of ideas and transparency of information concerning members' interests. We promote collaboration between and among mediators. We also facilitate engagement and communication amongst the mediators themselves and with third parties. And then finally, our objective is to arrange additional training, workshops and seminars for members, as well as opportunities for co-mediation for trainee mediators. So today's event aligns with the last mentioned objective of the society, and I will be speaking and we will discuss the practical implications of High Court Rule 41A for lawyers. So, 2020 will remain etched in our memories as the year when we all navigated uncharted waters without a map, but all pretty much in the same boat. I'm just going to share my screen with the slides. Is that visible to everybody?
Yes, thank you.
Thank you. Okay, so on the 9th of March, 2020, South Africa strode into the world of High Court aligned civil mediation as Rule 41A came into effect. So this was quite a laudable shift, even though in many other jurisdictions, such provisions already exist in their rules. For example, in the United Kingdom, the Court of Appeal has mediation panels associated with their functioning. Just to ensure that we're all on the same page as to what is mediation, I want to commence with a small definition. So mediation is a facilitated negotiation. It's conducted by an accredited, neutral, and impartial mediator with a view to achieving settlement, as opposed to an adjudicative process where an arbitrator or a judge makes a decision for the parties. In my practice, I have sometimes had to deal with the difficulty that it is not just the clients, but also their legal representatives themselves who don't fully comprehend the distinctions amongst mediation, arbitration, and litigation. So we all know what litigation means. And I just want to make some comments on this from the perspective of our topic today. Litigation takes a long time to bring a matter to finality. And this protracted delay is usually accompanied by an exorbitant bill. in the case of MB versus NB, a 2010 High Court reported case, also known as the Brownlee case, the South Gauteng High Court held that litigation is very expensive and that the parties ought to have explored cheaper means of resolving their dispute. The court strongly recommended that the parties should have used mediation as a means to resolve their dispute in order to save costs to their estates. And for the first time, a judge, who was Judge Brassey in this instance, imposed a cost sanction as a direct consequence of failure to mediate. And interestingly enough, the sanction in this case was imposed not on the parties themselves, but on their lawyers. So arbitration is a quasi-judicial method for resolving disputes outside the court, usually heard pursuant to an agreement between the parties of a dispute. And here an independent and impartial third party, the arbitrator, is chosen directly by the parties, and he or she will hear both sides of the dispute, make an award, and the parties undertake to accept this award as final and binding. Now, in mediation, a third party is involved who acts as a facilitator. So in a typical mediation, there's almost always a win-win solution or situation. So mediation as an ADR mechanism, which in my vocabulary stands for appropriate dispute resolution. It is non-adjudicative, and it's conducted, as I say, by an impartial third party, being the mediator, who assists the parties to reach mutual agreement. So mediation is not a new process in South Africa. For example, most employment disputes have actually been mediated since the 80s, and particularly through the CCMA since the mid-90s. Also, as a reminder, we already have in place rules for court-annexed mediation in the magistrates' court. And so mediation has become an option in many other fora. However, the introduction of Rule 41A has given impetus for like a sea change from civil litigation to mediation. And lawyers themselves are well placed generally, because a litigator who has been in the litigation game for some time will be able to assist their client and the mediator, in fact, on what the likely outcome will be based on what their experience has been of matters that don't settle. So what does Rule 41A address? With the advent of Rule 41A, not only are legal practitioners obliged to canvass the idea of mediation with their clients at the inception of the litigation process, Rule 41A now invites judges and Rule 37 case management judges to do the same as litigation proceedings progress. So any consideration of mediation must always be given against the backdrop of what is in the best interests of your client, insofar as the resolution of their matter is concerned. However, for lawyers, mediation is not always a simple choice. There are many practical reasons for this, not only as regards asking when and how they will get their fees, but it's also challenging to decide when and how to raise mediation with clients, especially in urgent matters. What is the best timing for mediation in the context of a particular dispute? And also when and how to approach the other side with a proposal to mediate. You know, some clients are sensitive, or they even become suspicious, especially at the start of a dispute, if you as the lawyer were to say, right, so you've had a fallout, let's discuss trying to settle your differences through mediation. Often that's a difficult discussion to have, especially if you have a heated or a belligerent client. So timing is everything when it comes to mediation. And we sometimes assume that any time is the right time. From your own experience, you will know that in litigation, some conflicts develop in such a way that we have to think strategically about when is the ideal moment to consider or initiate settlement. Now, to take this a step further, we also know from experience as litigators that broaching mediation with your opponents is easier said than done. I have faced situations where my client has asked, if I suggest mediation at this point, then they might think we're not confident about our case. So these are some of the reasons why, as lawyers, you might not find it easy to take that first step towards mediation. So before Rule 41A came into force, there was quite a buzz about its formulation and imminent promulgation. And I still know some lawyers who say, so I must consider mediation, but I really don't have time for that. We'll simply tick a box to say yay or nay. And my response to that is, as a professional and an officer of the court, that attitude flies in the face of one's ethical duties to the client and one's professional responsibility. So I know that what many of you as legal practitioners really want to know is, what does the new rule actually change? And perhaps you've also thought, I'll just indicate that my clients are interested in mediation, even though we're not, because the rule doesn't carry any sanction or immediate obligation. So look, there's always such a hazard when this kind of requirement makes its debut. But in my opinion, there are safeguards within the rule's construction, which, as you learn to implement it, you will come to realize that it's a significant rule that will become a game changer in the sphere of civil litigation. So why must you as lawyers take it seriously? The requirements are, the rule states that when you initiate litigation, be it in the form of issuing summons or by way of lodging an application, you have to complete Form 27 to indicate upfront, number one, whether or not you agree to refer the matter to mediation, and secondly, why you adopt that particular stance. So let us unpack these requirements. The first point is simple, to say yes or no to mediation. However, if you cast your eye down to the end of the rule, for those of you who have it before you, it's clause 9, paragraph B. When a court is faced with the allocation of costs, it may take into account what a party stated at the outset about whether or not they agree to mediate. So boom, right there we perceive the ingenious persuasion to appreciate the weight of this relatively new rule. I mean, imagine, if you will, when you sue out, if you say that you give favorable consideration to a mediated resolution, it's going to be very difficult for your opponent to say, no can do. Neither party wants to be seen as an obstacle to a potential settlement. And this is more so if it is one that could cause adverse consequences for costs later. So in my opinion, just in your statement at the outset, the rule will have an effect by causing the parties to consider mediation seriously. The second point is a little more comprehensive, and it says that you've actually got to not just indicate your position, but also you must give an explanation. So the rule requires each party to explain the reasons why they believe that the dispute is or is not mediatable. So the rule requires your statement to be clear and concise, and to my mind, this would imply a few lines. So basically what I'm saying is that in order to mitigate the risk of adverse costs orders at a later stage, a party will have to think carefully before opposing mediation. And a plaintiff opposing mediation will have to explain its stance cogently upfront to anticipate a response by a defendant that it agrees to mediate. So there may be things said upfront in the explanation that could trigger further thinking about mediation at a later stage. So for example, in the beginning, the plaintiff says, I refuse to mediate. He has no defense, he's ignored my demands. Now, that reasoning could sow the seed for the other side to say, well, maybe when you've heard my defense, this matter can be resolved through mediation. So even where the parties initially don't agree to mediate, the reasons they furnish for their positions may be a catalyst for mediation later. So from my experience, there are very few exceptions to the fact that most disputes can be mediated. An example that comes to mind is where the one party is pursuing a test case and whose purpose it is to set a precedent. Also, as an example of a reason for taking a position not to mediate, it may be that you both have already tried ad nauseum to settle. So when you lodge your application, you really believe it would be an exercise in futility to explore mediation. So those are the two pillars of the rule. Do you agree to mediate or not, and why? If the parties agree to refer their dispute to mediation, they must then both sign a minute that records their choice. At this point, it must also be emphasized that an agreement to mediate must also be finalized. The time periods that apply in terms of the court rules are then suspended. And here I refer to the delivery of pleadings and notices and the filing of affidavits, all of which are suspended from the date that the joint minute is signed. Obviously, this is not an indefinite suspension. Mediation should take place within at least about 30 days, but the period can be extended on good cause shown. As I've mentioned earlier, the rule does not contain a provision for early enforcement. And this makes sense to me. See, for example, you definitely don't want any interlocutory arguments, which, mind you, could entail an enforceable or justiciable element, and especially not at the outset, about whether or not you should enter into mediation. So the effects of Rule 41A in practice, your clients should be expecting you to talk about mediation as soon as possible. Actually, you should take clear instructions at the outset on an appropriate stance and strategy for settlement. Some of you may feel uncomfortable initially to raise this with your client or with the other side, but I think that merely by having been promulgated, the rule itself will help you to manage this. Now, especially if you're a large enough firm of attorneys, you may want to think about having a different team to dedicate itself to a settlement. So I usually suggest this when more complex matters are referred to me for mediation. You see, the rule requires you to consider mediation at an early stage of the dispute. And if you're in the throes of working out an effective litigation strategy, it may seem duplicitous or even almost an anathema to be concomitantly focusing on a settlement strategy. So where the costs involved warranted, and certainly where there is much at stake, I would recommend that a separate team is established with a mandate to consider mediation. In my experience, I've used this where I've dealt with medical malpractice cases. These have lent themselves to this approach. On the issue of complex matters, I must remind you that if some aspects of the dispute are more mediatable than others, then you and your opponent can still agree to just refer those aspects to mediation. And the upside is that this will have the positive outcome of reducing the issue or the issues that must eventually be decided by the court. So I cannot emphasize it enough. Both you as lawyers and your clients must approach mediation in good faith. If not, you could run the risk of derailing any possible settlement. Having it in the rules or anywhere else, having a good understanding of the mediation process, having parties willing to mediate or willing to submit to mediation doesn't automatically make the dispute resolvable. So there's no magic wand in mediation. I just think that particularly when one is talking to mediators, and sometimes as mediators, we're inclined to think that the problem is institutional. The problem is that the courts aren't encouraging it. The problem is that the parties aren't participating properly. And I suppose here I must throw down a challenge to say, yes, we need rational and well-prepared parties, but you also need good mediators. So parties and lawyers representing parties, their experience of mediation as an effective process, in my view, is going to be possibly the most material factor that will result in mediation becoming a normal part of our dispute resolution cycle, especially in civil matters. And perhaps it will play an even bigger role than the possibility of cost sanctions at a later stage if you make the wrong decision. So the mediation process needs to be explained clearly to the client, especially the fact that the mediator's role is facilitative, aimed at helping the disputants to reach a settlement agreement that they will implement. I often suggest to my referring attorneys that they should give the clients a memo, which they can digest at their leisure, which explains all this. Sometimes I also assist with drafting such a guide, in which I set out what is mediation, how is it different from arbitration and litigation, and how the mediation process will actually work in practice. So remember, what is said in mediation is also treated as without prejudice. It's inadmissible as evidence in any future process or forum. And as lawyers to your client, you must underscore that unlike litigation, mediation happens in a safe space of absolute confidentiality aimed purely at resolving the dispute. Even as a mediator, it's not to my advantage that the parties arrive at the mediation feeling apprehensive. So, as I've said, please reiterate to your client in preparation that the mediation is in absolutely confidential terms. Nothing can be used later in litigation if the mediation fails. So, as I've said, it's a safe space where they can brainstorm any option. And that's the beauty of mediation, where, the binary system of litigation, that is a win-lose outcome, everything's on the table with mediation. And litigation still remains one arrow in the quiver, but your clients should be encouraged to put anything on the table. Another caution is that you should encourage your clients not to make mediation conditional on the other party making upfront concessions. This too can derail the mediation before it even begins. So they should enter the mediation with a view to settlement and not be trying to get points scored early. So many lawyers up till today, a year and a half or so down the line, they don't have a solid experience of what mediation looks like. And in that sense, the whole experience might be new for you as lawyers and something that you'll have to adapt to. And to some degree, and this is just speculation, but I think it's fair in the circumstances. In the first place, I think we are probably going to see higher volumes of mediation processes coming through, which means that legal practitioners are going to have to get used to participating in mediation processes as an important part of their practice. And it's something that they are going to have to factor into their structures as to how they function in their practices. I also suspect that our traditional long forms of mediation, where you book a day and you set aside a whole day to do a mediation, although there are many cases where that is the ideal way of doing it, Rule 41A may well result in parties saying, well, we'll give it a stab, but we feel it's too much to set aside a whole day. Maybe we'll make it a half a day or set aside 4 to 5 hours and then see if this gets us anywhere. So that's possibly another implication, that we'll see more mediations, but perhaps slightly shorter in duration than what we've been used to as mediators in the past. So the other important thing that we need to understand, and in the context of what I'm going to say further on in my presentation, is that we need to understand Rule 41A mediations are happening outside of courts. So these processes are not being managed by the courts. Rule 41A is simply asking the parties whether they have mediated, whether they are willing to mediate, and encouraging them to do so through private engagements with mediators. So these processes are not managed or administered in any way by the courts. And especially if we have to see higher volumes of mediation processes coming through, then that has both an opportunity and a challenge for us as lawyers and for us as mediators. So lawyers have a very important role to play in the mediation process. I'm aware that many attorneys are concerned that the effect of Rule 41A is that they're going to lose work. So trust me, as lawyers, this is not the case. Lawyers still have a very important role to play in drafting the agreement to mediate, in drafting their clients' opening statements, and also in drafting the settlement agreements. My advice is that lawyers are also best positioned to advise their clients on the risks of not reaching agreement through mediation and on what is their best and worst alternatives to a mediated agreement. Some practical tips for lawyers: you need to serve your Rule 41A notice and make sure that it contains clear and concise reasons for your decision. You must then choose a suitable mediator especially if an area of specialization is relevant, you can check out our website. It's www.kznmediation.com for a list of accredited mediators and their areas of practice. You also need to prepare a proper agreement to mediate, where you will address aspects such as the date, the venue, the mandate, mediators' costs, the issue of confidentiality, the voluntary nature of the process. So as a lawyer, I encourage you to show willingness to engage flexibly in mediation. Attend the pre-mediation meetings and all the mediation sessions, avoid any dilatory conduct, and always act in good faith. As a lawyer, you also have to ensure that you have sufficient authority to engage in and conclude a successful mediation. Be fully prepared when you attend a mediation, cooperate, be constructive. And the parties will then need to inform the registrar of the court when mediation is complete. So within 5 days after concluding the mediation, the parties, along with the mediator, must issue a joint minute, which indicates whether or not the mediation was successful, and if so, whether full or partial settlement was reached. And also you need to enunciate the issues upon which agreement was reached and which do not therefore require a hearing by the court. And so as lawyers embracing Rule 41A and implementing it, you will be resolving your clients' disputes simply, better, faster, and with such a reputation and work ethic, you will surely attract many more clients in abundance. Yeah, that's it from me. Before I leave and before I forget, I want to thank Ghost Practice for their contribution and financial support to the society for the webinars that we are going to be holding this year. It was very generous of them, and for those of you who are interested, you can go onto their website if you're looking for a solution for your legal practice. That's it from me. I think we have ample time for questions. I'm not sure, Joe or Michelle, if you've picked up anything in the chat group that I can respond to.
Thanks, Ishara. No, there's nothing in the chat. So if anyone has got a question, Ishara, we did only get to slide 5. Is that correct? On your slides when you shared your screen. Was that correct?
Yes.
Oh, okay. Just don't.
Well, yeah. No, slide 6 is just a, let me share it. Slide 6 is just a quote that I like to. It's a quote from Mahatma Gandhi's autobiography called "The Story of My Experiments with Truth." It's an extract from that. He was a prolific mediator, not accredited though.
A good role model to have.
Yes.
Thank you, Ishara. If anyone has got questions, then you can put up your hand or just unmute yourself. There was something I wanted to comment on, Ishara, and now the thought has gone off my head. Oh, this was it. So let me, there is a question I'll get to in the chat. There is one question. So when you mediate, you suspend all litigation, but sometimes when someone's already when a client's already got a lawyer, then they go to mediation, they tend to sometimes I'm not a lawyer, but I am a mediator, but I have had clients go back to their lawyers during the mediation process and still get advice, even though they're not continuing with the litigation process, which can also be tricky because, then there's the legal side of things coming in, but you're trying to mediate. So how would you recommend dealing with that?
So you don't necessarily abandon litigation when you embark on mediation. So effectively what the rule does, it allows you to suspend the time frames for the DAs, you call it in law, the DAs for submitting certain documents, so there's time frames, 10 days, 20 days for filing affidavits, notices, etc. Once the agreement to mediate is signed, those timeframes are suspended. So it doesn't necessarily mean that you abandon litigation, but you've got some breathing space where you're not compelled to engage in an adversarial process, and you have that time space to engage in mediation instead. So if they do go back to their lawyers, that's well and good. I mean, that's who they know, that's who they have faith in. The lawyer can still advise them on their position, their strengths, etc. So I don't discourage it. But if the lawyer is not participating in the mediation, then I do discourage their intervention. But for the clients, the parties to the dispute who are engaged in a mediation, they have that grace period within which to fully and in a bona fides, committed way, engage constructively in mediation.
Yes, thank you for that. I must say, in my experience, when you mediate mediate clients who are coming to mediation without going through the Rule 41 or Form 27 first, they've got definitely a different perspective on trying to reach agreement than people who've gone to lawyers first and come through the Rule 41 process.
How do you experience that differently, Jo?
They seem much more adversarial. It's almost like they, as much as they choose to be there, they're not, they're not fully. I find sometimes the clients are not fully committed to the process. It's almost a ticking the box exercise. So, and that's something a mediator has to deal with and try and overcome, because I think people can be convinced, even if they didn't think so in the first place, they can be convinced that mediation is actually a way to resolve the dispute, even though they went to lawyers first. But sometimes it is a problem with the client that is conversing with the lawyer after mediation. They spend a week emailing a lawyer back and forth. When you come back to mediation, you're dealing with a different client who's got a different, now they've got a different perspective. It's quite difficult. Sometimes it's pause one step back. But be that as it may, I think this rule is fantastic. There is a question that somebody asked: can you make the slides available to the participants, please?
Yes.
Thank you. So
yes,
we will make sure we send them off. Ian, you've got a question. Would you like to unmute?
You're still muted, Ian.
Can you hear me now?
Yes.
Yes. I'm wondering if anybody knows what the practical effect so far has been of the amendment to the rules and the implementation of Rule 37A. Has it resulted in more mediations? I had a matter where I issued summons shortly after the commencement of the amendment, and I served the form inviting the defendants to advise whether they were prepared to participate in mediation. And I got a rather hedged response that it was too early to consider yet. So they wouldn't commit themselves to saying, no, we won't mediate. They wanted to investigate. Well, that is a long time ago, and I still haven't heard anything. I suspect that we're still going to have a lot of resistance to mediation because of the fear practitioners have of being deprived of fees. But I'd like to know, I'd be delighted to hear from somebody who's able to tell us that there has been a mediation taking place, or have been mediations taking place as a result of the new rule.
So you're talking about Rule 37A, the
Yes.
judicial case
Yes.
case management.
Yes.
Yeah. From my experience, I haven't had a lot of success with Rule 37A moving forward in a proper mediation forum, but I have had in terms of Rule 41A. I must say, though, that if I've done 5 Rule 41A, if we've done five matters that have to go through Rule 41A, only 2 have actually gone into mediation. So the rest have simply been, as I've cautioned against, a tick box approach that we don't feel at this stage. And like I said, also, timing is everything. So if initially there is resistance, there is nothing that stops one as the issues become ventilated through the exchange of pleadings or affidavits that you can pick up. And as an experienced mediator, you will see yourself, well, you're a legal practitioner too, but you will see for yourself that there are certain aspects on which you'll be able to narrow down the issues and reach some kind of settlement through mediation. So when you consider all that, you could still raise it even closer to the trial. And I've had one case where the trial has commenced, and we foresaw that, look, there are some major issues that we can mediate on. So we suspended the evidence, and we asked the judge if we could go for mediation, and he was very agreeable, and we managed to sort out those issues, and we came back with just one issue to be heard before the court. So those are the various approaches that, if at the beginning it seems impossible, then, like I say, as the exchange of papers proceeds and you pick up that you can always raise it again, and even at the trial stage. Because sometimes, I mean, look, the judges are not happy that you settle at the threshold of the court on the day of trial. But I must say that given their court role, even with Rule 37A, the court role is quite heavy. And it's meant to expedite matters, but there are often bottlenecks, etc. So judges in practice are grateful when parties indicate that they want to circumvent the trial proceedings and try to settle.
Yeah, I suppose a pre-trial conference too is a good time to raise it.
Yeah. Are there any other questions?
I don't see any hands up. Anybody else? No, I think that's it. Ishara, can I thank you on behalf of the KZN Society for shedding light on that new rule? I think even though it came in March 2020, it's still very helpful to explain it and how it works in practice.
Thank you.
It's very useful for me.
It's been a pleasure.
Thanks, Ishara.
It was helpful. Thank you.
I think our next webinar will be taking place on the 2nd Tuesday in May, if I'm not mistaken, but we will keep members informed.
Yes,
And,
we will put out an advert.
Advertise it.
Yeah.
Great. Thank you so much everyone for joining us for this lunch hour webinar series, the first. And thanks again, Ishara.
Thank you, Joe. Thank you for all your back office support as well.
Great. We'll be sending everyone the slides, and if
Yes,
anyone wants a recording, we can absolutely send that too.
Thank you. Thank you, everybody, and goodbye.
Bye-bye.